Hello everyone, this is Stuti Khare from Institute of Law Nirma University, interning under the Amikus Qriae. Today we will be discussing about the National Tribunal Commission. So, in administrative law, the term tribunal is used in a significant sense and refers to only the adjudicatory bodies which lie outside the sphere of the ordinary judicial system. Technically, in India, the judicial powers are vested in the courts, which aims to safeguard the rights of the individuals and promotes justice. Therefore, to institute an effective system of the judiciary with fewer complexities, the judicial powers are delegated to the administrative authorities, thus giving rise to the administrative tribunals or administrative adjudicatory bodies which hold quasi-judicial features. The objectives of these tribunals are to provide for a forum to deal exclusively with service matters which offloaded the burden of the cases of High Court from their jurisdiction, to provide inexpensive and speedy relief to government servants in service matters, that is Article 323A, and other matters which are included in Article 323B of Indian Constitution, to provide special powers to the tribunals to make their own special powers and procedures and not to be guided by the CPC or law of evidence but to work according to the rules of natural justice. In the year 1985, Parliament passed the Administrative Tribunals Act in pursuant of Article 323A of the Constitution, which states that there must be a central administrative tribunal, that is CAT for the union, and an SAT for every state. So, what was the need for the National Tribunal Commission? Expressing the concern over a disturbing trend of the government not implementing directions of the tribunals and thus undermining their independence, the Supreme Court had directed the setting up of an independent National Tribunals Commission to supervise the appointments and functioning of the tribunals. To ensure that tribunals should not function as another department under the executive and there is effective dispensation of justice, there is a need of an independency from executive control, rendering them credible and generating public confidence. There also exists a concern over the sad state of affairs in the tribunals, as some of them are dysfunctional due to large scale vacancies. Some of the bodies cannot function without the presiding officer in view of the position in respective acts. Most of these tribunals have not been provided with adequate residential accommodations, proper office infrastructure, or adequate supporting staff. Many of the posts of those bodies are lying vacant, and also cases are mounting in those bodies, and the purpose for which those bodies were created have been defeated. The creation of National Tribunals Commission will be to oversee selection process, eligibility criteria for appointment, introduction of common eligibility criteria for removal of chairmen and members, and also for meeting the requirement of infrastructural and financial resources. NTC should deal with tribunals only. The regulatory bodies which do not perform quasi-judicial functions should be kept out of the purview of this bill and may be dealt with separately. Comprehensive legislation proposing uniform condition of service with regard to eligibility conditions for appointment, ground of removal, uniform retirement age, allowances, and other perquisites for chairperson and members of the tribunals or commissions belonging to the same category, and these functions and responsibilities will be vested in the National Tribunal Commission, which may be created for the purpose. It also conducts for disciplinary proceedings against the members of tribunals and to take care of the administrative and infrastructural needs of the tribunals in an appropriate manner. So, till the National Tribunals Commission is constituted, a separate wing in the Ministry of Finance, Government of India shall be established to cater the requirements of the tribunals. Till amendments are carried out in 2020 rules, the search cum selection committee should comprise of Chief Justice of India or his nominee as the chairperson and others including the outgoing chairman or president of the tribunal in case of appointment of chairman or president and secretary to the Ministry of Law and Justice. The chairpersons, vice chairpersons, and the members of the tribunal shall hold office for a term of 5 years and shall be eligible for reappointment. Rule 19, subclause 2 of the 2020 rules shall be amended to provide that the vice chairman and vice chairperson, along with the vice president and other members, shall hold office till they attain the age of 67 years. Rule 4 Clause 2 of 2020 rules shall be amended to provide that the search cum selection committee shall recommend the name of one person for appointment to each post instead of a panel of names for appointment to each post, and another name may be recommended to be included in the waiting list. Center has to make appointments to the tribunals in 3 months from the date on which the search cum selection committee made recommendations. Any appointments made after the 2020 rules came into force on February 12, 2020 shall be governed by it, subject to the modifications and appointments under the 2020 rules till the date of this verdict shall not be considered invalid. Chairpersons, vice chairpersons, and members of the tribunals who are appointed prior to February 12, 2020 shall be governed by the parent statutes and rules as per they were appointed. The court directed the government to strictly adhere to the directions given in the case of Madras Bar Association versus Union of India 2020 until the rules come into effect. Thank you.